Court would next call the matter of Thomas LaForest versus Rebecca Ledbetter, file number 19-17998DM. Do we have the parties on that matter present?
Yes, sir.
Present, Your Honor.
All right, parties are before the court. Mr. LaForest had filed a ex parte motion, which was denied, but then referred to this court for a hearing on his motion. So, Mr. LaForest, what are you looking to change?
So when we just had our evidentiary hearing last month, I believe I probably misspoke, and that's why we're in the situation we are now. So at our evidentiary hearing, we'd set up parenting time to be every Friday and then every other Saturday, included with the Fridays. And I probably said, when you asked about summers, I said, let's just keep it this way, do standard parenting time. Well, I had no idea that standard parenting time is 2 weeks on with the defendant and 1 week with the plaintiff. We went through the first 2 weeks. She's just now started her second 2 weeks with my son, with our son. And my son did express to me, he told me that he didn't want to stay for 2 weeks. He's young, he's about to be 7, but he begged and pleaded with me to not make him go back for 2 weeks. He didn't give me a reason why, and I think it's just because of his anxiety. I really believe that that's all it is. And so me and Rebecca are trying to work together. I just would really like for the court to take into consideration that my son doesn't communicate verbally with the defendant. However, that being said, I believe that me and the defendant are working together to try to address this. We've set up a way for him to be able to communicate to the defendant if he wants to come home by walking to the door and pointing at it. So I guess, I put this motion in wanting to correct the parenting time to what we had at the evidentiary hearing. However, I think I'm okay with what we currently have. As long as me and the defendant can continue communicating and working together, I think that we'll be fine, because we both want what's best for our son. And if we wanted to move to mediation, I would be open to moving to mediation and free up the court's docket.
All right, so you're asking to either withdraw your motion, or are you asking a referral to mediation?
Referral to mediation, preferably.
All right, Ms. Ledbetter, any issue in participating in mediation?
Yeah, I think that's the best thing for Jacob. Going to court and, seeing his parents fighting or whatnot isn't the best thing. And I'm always open to whatever Jacob wants. But I mean, granted, we are the parents, so he is getting better. His anxiety is getting better, and we're working on therapy. And I do think, being that when I go to work, his dad watches him, so he does get to see him. I think that helps a lot. So he can communicate with his father, and his father could communicate back with me if there's some kind of concerns or anything. I do have word flashcards kind of type thing with pictures, and he does communicate. He does do sign language. I'm willing to do mediation, sir. I think that's great.
All right, thank you. All right, well, so given those statements, we will do a referral to mediation to see if the parties can address what they would like to do for the summer parenting time. Anything else, Mr. LaForest?
No, thank you for your time, Your Honor.
All right. we will refer you for mediation. I guess we will then set a status conference down the road to see if there's an agreement at mediation or if we need to address the matter further.
All right. Thank you, Your Honor.
Thank you,
Thank
Your
you.
Honor.
041 DS. We have the parties on that matter present.
Yes, I'm here.
I'm here.
Thank you. And sir, this is your motion regarding support. Is that correct?
Yes, sir.
And what are you asking to change?
So I'm still driving the full way. Since our last adjournment, I think at the evidentiary hearing, Ms. Lewis stated that she's still not going to meet me halfway, that she'll just compensate me. But as we all know, gas has went up. And it's too expensive. And if I'm driving the full way, at this point, I want support reduced. Because I had to get a new vehicle because my last one broke down. Because of all the driving I did.
Is she paying you when you drive the whole way?
Yeah, the $40 there and back. I missed February because she stated that because she didn't get my child support that she couldn't pay me compensation. So basically I'm paying myself to drive up there. So
Ma'am, anything that you want to say?
Well, financially, I was struggling in February that he mentioned, and every single time he wants his visitation, I pay him the money. I pay him the full $40. I financially, that's very helpful.
You said anytime you want spare time. Are you guys following the schedule? Or are there times where it's not? You guys don't meet?
Yes,
yeah.
we're following the schedule, yeah.
Okay.
And I was also gonna ask, because our son is with me majority of the summer, if the weeks that he's with me, or like to calculate the time that he's with me, can I not pay the support because he's with me 8 weeks out of the summer, and I think there's 12 total, and I'm still paying her to support him, but he's with me majority of the time.
Well, the
And
overnights are calculated based on a yearly and averaged out. So you can't choose to not pay support because he's with you more during those months, because that's factored into the calculation and spread out over the entire year.
Okay. I just know he's going to camp when he's here, so that's why I was like, it'll help a little bit, but that's fine. No issues.
So what the court has to consider when it comes to changing a support amount is whether or not there's proper cause or change of circumstances. It sounds like Mr. Velez's argument is that they agreed to an amount before, and you don't feel that amount is sufficient compensation for the drive, sir?
No, it's not. It costs to get there and back. It costs roughly about $70, and that's 7 hours of driving to go all the way up there. And I know Miss Lewis has a better reliable vehicle because I saw basically a brand new truck that I guess her grandma or her mom drives, and I'm just a little frustrated.
So you believe it cost you round trip about $70?
There and back, yes. So that's why I wanted the support reduced by roughly about 140, because it's, it'd be about 300 for support.
Sounds like if your round trip costs you 70 and you are
I don't
driving the
even
full way,
get.
so
Go ahead.
driving the full way, so meeting halfway, I mean, you'd have to drive halfway either way, then you do the extra halfway. So half of that is 35, she's paying you 40. That was part of the court's, well, that was part of the agreement the parties reached back when we had the custody hearing. Ms. Luz, do you think that figure, the $40, should be increased at all, or do you think that is the appropriate figure?
I feel like it's appropriate because I can't afford a whole lot of money. I only get paid so much in my Social Security.
Do you ever make the drive, or is it just that he has to do it all the time now?
I don't make the drive, no, because I do not have a dependable ride, which we talked about last hearing.
All right, so we were, any last thing that you want to say, sir?
Well, if she can't meet me halfway, I just feel like it should be reduced and then just take the compensation away, and then that'll help at this point because I'm paying $400 and something, and then she's giving me 40, but it's like at this point she's not going to meet me halfway. Just take the compensation out and reduce the support, and then I'll just pay with my own money.
All right, so the parties do have an existing support order. Mr. Velez has filed a motion to change that, asking for a reduction due to travel expenses. The parties do have an order from October 25. There was discussions that went back and forth regarding that order. Ultimately, it came out that the exchanges would be halfway. If one party had to make the entire trip, then the other party would have to pay $40. Mr. Velez is asking that be removed and that his support simply be reduced instead. Testimony supports that Ms. Luz is paying that money when for those trips, is paying that $40 that was discussed and agreed to back in October of 25. The court has decided there's proper cause or change of circumstances to change a support order. Based on the statements today, I do not believe there is proper cause or change of circumstances, so I will deny the motion. The orders would remain in place. Either party has the right to file an objection to this recommendation and have the matter heard before the judge. You have to file that objection within 21 days of the mailing of the recommended order, and that information will be provided in the paperwork that you receive from the court. All right, thank you both for appearing. You are all set.
All right, thank you.
The defendant father, Andrew Tinsley. Mr. Tinsley and I appear in separate locations via Zoom this morning.
Thank you. All right, we've got a pending motion to change domicile. Is that correct?
That's correct, Your Honor. There was also a show cause order that was adjourned at Ms. DeVozo's request to today.
Right. And as to the domicile, is there any resolution, or are you asking for an evidentiary hearing?
We are asking for an evidentiary hearing as to both matters. I spoke to Ms. DeVozo this morning. I do not believe that we are close to a resolution at this point, and we would just ask for the soonest the court could get us in on a trial date.
Ms.
And Your
DeVozo, is
Honor.
that correct?
Oh, may I, Your Honor?
Yes.
Thank you. Your Honor, we also, in addition to a response to the motion to change domicile, we filed a motion to modify custody as well. So yes, I'm in agreement that probably everything should be scheduled for an evidentiary hearing, both motions and the show cause as well. I'm also think that it's likely I will need some discovery, and I don't know, I don't remember if counsel said she would or not, but I would like some opportunity to conduct some discovery related to the motion before we conduct a trial if possible.
All right, so before me, you'll get a 3-hour evidentiary hearing, and obviously you've got a right to a de novo hearing after that. You don't have time to get certain witnesses in or testimony in. I just gave away my last August date this morning, so my next available date is September 16th at 1 o'clock. Is that it? Is council available for that date?
That's far enough out that I'm sure I'll be able to make that. Let me double check it. September
16th at 1 o'clock?
16th at 1 o'clock. And I would also, if I could, ask Mr. Tinsley to weigh in on whether or not that's going to work for him. He is employed, and I want to make sure that won't interfere with his employment before we set it.
That would be work for me, Your Honor.
Okay, great. So yeah, that works for me, Your Honor.
Your Honor, that also works for my calendar. I think I'm actually before you earlier in the day for a status conference, but I think 1 o'clock would be just fine to start that 3-hour hearing.
All right, so we'll schedule a matter for a evidentiary hearing September 16th at 1 o'clock. Parties are to file witness and exhibit lists 21 days prior. Looks like the children are both of age to be interviewed, so there would be a preference interview with the children. So whoever has them that day should have them here at 12:45 for the preference interview. All right, any questions, counsel?
Yes, Your Honor. The hearing, is that expected to be in person? Mr. Tinsley resides in Maryland, so I want to make sure that we can be clear about what the expectation is for him.
They are typically in-person hearings. Mr. Tinsley, does that create a hardship for you to be here for that hearing date?
Yes, Your Honor. It's quite a logistical and cost burden to be in person.
All right.
Your Honor, may
Ms.
I?
DeVozo,
Oh, sorry.
you
If
can
I
be,
were,
Ms. DeVozo.
yes.
Ms. Wise, what is your, any objection to Mr. Tinsley appearing by Zoom for that hearing?
I do object to that, Your Honor, and it's certainly not because I want Mr. Tinsley to spend any extra money that he needs to or to have some difficulties at work. But given what has been put in the court record, I just received the pleadings in the mail yesterday. There's going to be extensive cross-examination, and I'm pretty uncomfortable with the idea that Mr. Tinsley would do that that cross-examination remotely from Maryland. I think that it's more appropriate for him to be in person given the allegations he set forth in his present motion.
Your Honor, I think that
Yes.
if I'm in person and Mr. Tinsley is on Zoom, he has no problem appearing on the camera screen. He's appearing with the screen on today. He's very familiar with the technology associated with appearing by Zoom. We've done this before. There was extensive litigation in a prior Roscommon County proceeding. And I think what I would request from the court is if I could be in person to make sure I'm there so that there's no problem introducing evidence, documents, whatever we need to do, and then allow him to appear by Zoom. I can't see how anybody's going to be prejudiced by that.
Well, can I just make a
The
quick
other thing
clarification?
is, the
Sorry,
other
Wendy,
thing
go
is
ahead.
that Mr. Tinsley was required to travel here extensively all throughout 2025 and into 2026. I mean, he must have been here like 4 times in the last year for hearings, and it's been extremely burdensome for him. So that's all. Thank you.
All right, go ahead, Ms. Wise.
I just want to say that, in Roscommon, he was required to be in person. So there was no evidentiary hearings that I was a part of. Now, there was prior counsel for Ms. Jenowick and part of that. So maybe there was an evidentiary hearing held where Mr. Tinsley was allowed via Zoom. But as since I've been on the file, he has been required to come to Michigan in person for those hearings. And I think that's for good reason. This is a complicated case. He certainly wasn't brought here, just on Ms. Jenowick's, own volition. He was also litigating things in that county. So I really do have some concerns given the behaviors of Mr. Tinsley in the past that I would not have a fair opportunity to cross-examine him if he's allowed to do that virtually.
Your Honor.
So, well, I'm all set. So the court typically, not typically, I require attorneys and parties to be in person. Sometimes that can be changed given situations. Witnesses, different witnesses, expert witnesses, those type of things, I freely grant the ability to appear by Zoom. With the parties, it's a little more difficult given the potential extensive testimony. It's harder for the court to assess and judge credibility of witnesses that are appearing by Zoom as opposed to in person. The process with exhibits or reviewing documents is much more difficult with a witness when they are on Zoom and other individuals are in the courtroom. So without a stipulation, I am going to require an in-person presence, but I will, if he needs a different date to kind of make arrangements and more time to get that done, I'm not opposed to that. I've got a lot of time in September, so I've got the 16th, the 23rd, and the 30th. I know those are Wednesdays, so probably not the greatest day of the week, but they're available. So if he feels that a little bit of a later appearance would be better to make any arrangements for work, I can accommodate that. But I am going to require in-person attendance for the parties and the attorneys. So Mr. Tinsley, knowing that, do you think a different date would be more helpful so you can make the arrangements, or do you want to stick with the 16th?
That date works, Your Honor. I'll make arrangements.
All right, I appreciate your understanding, sir. It's nothing against you. It's just court procedure. All right, so we'll be set on September 16th at 1 o'clock.
Right.
Thank you, Your Honor.
All right.
Sounds good.
Thank
Thank you.
everyone.
All right. Have a good day.
Court next calls the matter of Anjulia Kapanke versus Robbie RG, file number 14-15291 DP. Do we have the parties on that matter present?
I'm here, Your Honor.
All right. And I'm sorry, it's Brandow now, correct?
Correct.
And Miss Brandow, this is your motion, is that correct?
Yes.
And what are you looking to change?
Custody.
I'm sorry, I didn't catch that. What are you looking to change?
Custody.
Okay. What is the current arrangement?
We have joint legal and he's got physical custody. And then I've been getting them every other weekend, even though it's 1 3-day weekend a month.
And
And all the holidays.
You're asking to have the primary physical custody?
Yes, please.
And what has changed since the last order?
Their schooling has, well, it was supposed to be in the first court hearing, and it was not presented, but they were missing school and going through issues in school, and which I have all documented and been in contact with the schooling and their health. They need physicals done, which I've done, taken them for that. And my oldest has seen the dentist, and they just need all that switched up here, and it's hard to get them into the doctors with their address being downstate, and they don't want to end up billing twice for seeing the children up here and their address being there. And I'm just going through some issues with it.
So you're asking that you have the primary physical custody and that he have some weekend parenting time?
Correct.
All right. Mr. Fargi, are you in agreement or disagreement?
Disagreement.
Okay. You heard what she's indicated as to some issues that are going on. Do you agree with those issues or disagree with those issues?
I disagree.
How are they doing in school?
They're actually doing okay. They'll be doing better if Anjulia wasn't doing the things she was doing. Anjulia was calling the kids out of school. She would call my oldest daughter out of school because she had her own car. She was calling her out of school a lot, and then she would go and pick up, my other kids. I had at the end of the year, I got a warning for truancy for my oldest daughter. Wasn't in truancy this year for any of the kids. I didn't go to court for truancy. It was a warning for my oldest because she was getting let out a lot. I did let my daughter out at times. When she wasn't feeling good, she would call home sick, saying she was throwing up, and so I would let her come home, or if she would get her schoolwork and come home and do her schoolwork online. So they were doing real great. The problem that we're really having, and with the dentist and everything, they have seen the dentist, they have seen the doctors.
All right, well, I'm going to set the matter for a hearing. I know you both have had attorneys in the past. Do either one of you intend to hire an attorney for these motions or represent yourself?
I do not. I'm representing myself, Your Honor.
I will represent myself too.
All right. I just ask because that kind of impacts how much time is potentially needed.
Your Honor, I am going to have witnesses too, like the school, the doctors up here.
All right. All right, so I'll have to give you a 3-hour time period. It will be in September because that's our next available dates.
Okay.
Looks like one of the children is going to be 18 by that time. Is that correct?
Yes.
All right. So the court would obviously no longer have any jurisdiction over an 18-year-old. So I've got September 23rd available at either 9 a.m. or 1 p.m.
9, please.
Sir, I know you're coming from downstate. Would you rather have a 9 o'clock or a 1 o'clock, sir?
1 o'clock.
All right.
And
All right.
Could this be Zoom? Over Zoom?
Nope.
It has to be in person?
Yes, sir.
Okay.
All right, so we're going to set it for September 23rd at 1 p.m. That is an in-person evidentiary hearing. I do need to meet with the children for a preference interview, so they should be here at 12:45 that day.
Okay.
Any witness and exhibit list needs to be filed 21 days in advance. Any questions, Ms. Brando?
None, Your Honor.
Questions, Mr. Barge?
No, none.
All right, thank you both for appearing. We'll see you back here September 23rd. You will get a notice. Thank you.
Thank you.